to a company formed by the defendant, Eli Global, and that company was formed for the purposes of purchasing JTJ's business. The cash consideration under the purchase agreement was $4 million. $1 million of that was a promissory note that was issued and signed by Eli Global. That note called for 3 annual payments of approximately $341,000 in 2017, 18, and 19. Eli Global made the 2017 and 2018 payment, but refused to make the 2019 payment, so this lawsuit followed. We moved for partial summary judgment on all of the elements of our breach of contract claim, with the exception of damages, and we explicitly reserved the question of any affirmative defenses that Eli Global may have for later motions or a trial if ultimately necessary. So that means, and I think both parties will concede this because it's set forth in the Doncaster case that both parties cite, we only need to prove 4 facts to prevail on summary judgment. First, that there is a note. That's not in dispute. Both parties attached the note to their summary judgment briefing. Second, that Eli Global signed the note. Again, that's not in dispute. Both copies of the note were signed by Greg Lindberg, who is the chairman of Eli Global LLC. The third fact is that JTJ is the holder of the note. That's not in dispute. We, of course, we're the seller, we're the lender under the note. We've received payments under the note in 2017 and 18, and we demanded payments for the final payment for the note in 2019. And then finally, that there's a balance due under the note. That doesn't appear to be contested either, that the third payment due in 2019 has never been paid. There's no challenge to any of these facts, so our motion for partial summary judgment should be granted. Instead of contesting those facts, Eli Global tries to argue that one of their affirmative defenses, their consideration affirmative defense, would preclude summary judgment in this case. Now, procedurally, that's incorrect because a party can obtain summary judgment on all or part of a claim and then reserve any other matters for later determination, which is exactly what our partial motion seeks. But substantively, the idea that the note isn't supported by consideration is a bit preposterous. The mantra seems to be that because Eli Global didn't sign the asset purchase agreement, there can't have been consideration for the note. But that's incorrect. What Eli Global got by function of the note was that a company it owned and controlled, or to use the language of the APA, a company that was, quote, a member of the Eli Global family of companies, was able to purchase JTJ's business. And that inured to the benefit of Eli Global because Eli Global is the owner of the company that purchased the business. So there was consideration that Eli Global received. Their argument would be akin to someone saying that a note has no consideration or a guarantee has no consideration unless the guarantor or the signatory on the note was not a party to the underlying agreement. And that's simply not the law. If a parent corporation guarantees a note for a subsidiary entity or enters into a note, there is consideration for that. I mean, certainly you wouldn't in an individual scenario accept the idea of, well, I took out a promissory note to send my son to college, but when the college came calling, I said, but I never enrolled for Government 101. That argument doesn't make any sense. There's a reason why they entered into this note, and it was to allow their subsidiary company to complete the transaction and purchase JTJ's business. Their only other argument was that JTJ's business declined by 50% after the sale. Now, we challenged the validity of that allegation, but in any event, it's irrelevant because arguing that you made a bad deal or that the deal didn't turn out the way that you wanted it to is not evidence that there was no deal in the first place. It's merely a basis to claim, if there is a factual basis, that perhaps you were defrauded or perhaps you have some other counterclaim to bring against JTJ. Well, they haven't done that here. There is a counterclaim on file. The counterclaim does not assert anything related to fraud, and for good reason, because the agreement bars that claim. And very simply, the fraud claim as alleged by Eli Global is that during the due diligence process, some alleged misstatements were made concerning whether or not the contracts that JTJ had with its customers would continue on after the closing of the transaction. And that representation made outside of the contract is prohibited by the terms of the contract. The contract has an enforceable disclaimer of reliance clause that says that the only thing that's being relied upon are statements made in the contract. And the only statements made in the APA regarding the contract is a representation or warranty that expired on its own terms in 2018, because the parties agreed in the contract that for certain representations, claims would have to be made under those representations within 2 years after closing, or else those would expire. And that's true for the representations made about the contracts, the enforceability of JTJ's contracts. Having failed to bring a claim, and in fact, having made the payments under the note, it's clear what this tactic now is. It's an attempt to escape responsibility for making the final payment on the note. They made the payment on the note in 2017, even though they're claiming that within the first 6 months of the closing of the transaction, business fell off by 50%. They made the payment in 2018, even though that was the year that they made the payment, frankly, on the exact same date that their ability to bring a claim for fraud related to JTJ's contracts expired. What we have here is just an attempt to continue to avoid payment on the note. And all we have for this particular summary judgment motion to be considered is, do we have an enforceable note? The damages and defenses are to be determined at a later date. There's no dispute that we have an enforceable note. If they think they have an affirmative defense or even a counterclaim, they can bring that at a later date. But right now, the court should grant the motion, the partial motion, and enter summary judgment on all elements of our breach of contract claim except damages.
Response?
Yes, Your Honor. What I hear plaintiff's counsel asking this court, because it's somewhat confusing to me, is that they're asking this court to decide, do we have an enforceable note? Is there a valid contract? And a contract is only valid, as we all know, if it's supported by consideration. That's essential to their case, is to show that valid consideration was conveyed to Eli Global. The only parties to the contract on which this lawsuit is based is Eli Global and the plaintiff's predecessor. When we conducted some written discovery in this case, Your Honor, and we've cited it for you in our response, and when we asked them what was the consideration given for this note, because it's not your typical note, they're not claiming that they loaned a certain amount of money to Eli Global and Eli Global has failed to pay that back. When we asked them what the consideration was for this note, they went through and said, well, the consideration was providing this business to a company that's within the companies of Eli Global. And in fact, they're arguing this benefit because it's some type of affiliation that they haven't proven through the summary judgment, but that somehow there's this inherent benefit to Eli Global because business was conveyed to a company that was within a sphere. That doesn't get you to consideration conveyed to Eli Global. Well, at least doesn't get you to prove it as a matter of law. And they've cited no case law, and I haven't been able to find any case law that says, oh, because a benefit was given to an affiliate or another company within your group of companies or whatnot, that conveyed consideration under a single contract is what we're talking about here. The APA, everything else that is tangential that did not involve Eli Global. Eli Global wasn't a signatory, and there's no dispute that Eli Global wasn't a party to the asset purchase agreement. And so there's no consideration provided. That's essential to them proving that there is a valid contract. That's step one before they get down the road. This idea that they can have the court on one hand order here today through summary judgment that there's a valid contract and then say, but we reserve the consideration issue on affirmative defense doesn't make any sense. Yes, there's a burden shifting under our law that the lack of consideration does shift that burden to us as we go about this case, but it's still an element of their having a valid contract. So the court simply on that basis alone can't grant summary judgment at this point. It doesn't really make much sense to do so at this point in the case either. I did want to bring up here, Your Honor, that we did have a slight clerical error, and opposing counsel hasn't objected to it, but I just wanted to make sure that I was clear with the court. we attached an affidavit to our response for summary judgment by Mr. Scott Hall. In a clerical error, we attached a different affidavit of Mr. Hall that was for earlier in this case when the summary judgment was continued at the, I think, first month in this case. We have since filed the corrected affidavit. We would ask the court's leave to consider that affidavit. There's no surprise here, as the facts of that affidavit were clearly cited in our response. It was an inadvertent mistake in that the wrong affidavit was initially attached by Mr. Scott Hall. So we would ask leave for the court to consider.
Any objection, Mr. Ryan, to that?
No, Your Honor.
All right. Leave is granted. Make sure you include that in any order we have. Okay. Anything else, Mr. Reed?
Well, as to the second argument that the plaintiff made here as to performance, that is another basis why the court shouldn't grant here, is that they have to show that they performed. If the court gets by the first hurdle and that there's somehow this benefit conveyed to Eli Global, performance, or that they tendered performance, is what's important here. What was their performance under the note? Well, it goes back somehow to this convoluted idea that was the APA. That's where we've raised the fact issue that they didn't perform under the APA and conveying what they promised to convey to the affiliated company. We included that argument while we don't believe that there is consideration. You get to that step, but in case the court does say, okay, there could be some idea that a benefit was conveyed to Eli Global in the note based upon the APA conveying a business to a company within the sphere, then there is at least a fact issue as to whether they performed, because what they conveyed was not as represented. Therefore, there'd be a fact issue on performance, which would preclude summary judgment as well.
Okay, response. And let me ask one question. So remind me, when is this case set for trial, or is it set for trial?
Your Honor, I believe it's been set. I think the setting is in October, but I honestly don't remember.
Mr. Reed, do you know, or Ms. Lynch?
It's a ways. I don't remember, Your Honor. We're still a ways out. This is a relative.
Rhonda, can you check and text it to me? Okay, Mr. Ryan.
Your Honor, I just checked. We're set for October 6th.
Okay.
So in response, Your Honor, so 4 quick points. First is I'd urge the court to look at the Doncaster case, which is the case cited by both parties related to suit on a promissory note. It addresses this consideration issue. The existence of a contract presumes consideration, because a party, and I mean, this makes practical sense, a party would not sign a contract, bind themselves to a contract, unless that contract gave them some benefit. And that was found in the Doncaster case, which was a suit on a note case. And it also makes sense here in a legal sense. As Mr. Reed pointed out, there is a burden shifting that happens once we establish the existence of the contract, which is all Doncaster said we had to establish. Once that happens, they've got to show either lack of consideration or failure of consideration. Now, failure of consideration is the tendered performance point, which I'll address in a minute. Lack of consideration is this idea that Eli Global didn't get anything. And that leads to the second point. The affiliation between these two companies is proven by the APA itself. If you look in the preamble to the asset purchase agreement, it lists that the buyer, which is this company called FTGU, they were trying to take the name of what JTJ's company used to be so that they could use that same name in the marketplace. This new company that Eli Global created, that company would then have the ability to operate as a member of the Eli Global family of companies. So what you have is you have a new company that's created, and the parent company making a promise for the benefit of the subsidiary or affiliated company that inures to our benefit, obviously as the plaintiff, but that also induces the sale. So, you know, when Mr. Reed says this is confusing or convoluted, it's not at all. This happens all the time. Parties that don't have enough money or enough credit to get a deal done go to another party to provide that credit or support, which is exactly what happened here. We got a $1 million promissory note. Third, this question of did we tender performance? Of course we tendered performance. Their argument is you didn't do everything that you were required to do by the agreement because these contracts all didn't transfer and some of them failed. That's not tendering performance. That's that you didn't live up to your end of the bargain. That's breach. I mean, if we have a contract for the sale of a car and I drive the car to your house, you hand me the money and I give you the keys to the car, I've tendered. If you can't get the thing into your driveway because I gave you a lemon, you have a claim for breach, but you don't have an argument that I didn't tender performance because I came to your house and I gave you the keys at the same time you gave me the cash. And then this final point about the affidavit, while Mr. Reed is right and we don't have any objection to it, Your Honor, I mean, it's crazy times. So, you know, the fact that there was a clerical error is completely understandable. That's the reason, the affidavit, though, in my mind, for why we have to act now on the partial motion. As the court will recall, shortly after the defendant answered, we filed this motion and then set it for hearing. There was a request then that it be delayed 6 months. The court agreed to delay it 3 months. And we don't have any quibble with that, but we did say at the time, Your Honor, they don't need any additional time to question the validity of this agreement. This is a valid agreement. If they have any issues with our performance, they have any claims for fraud, they can always bring them as a counterclaim. They can always try to pursue them in the case. And we said, and we were told, no, we need to take written discovery. We need to take depositions. Otherwise, we won't be able to respond to this motion. In the months since, there have been no depositions. They haven't deposed anyone from the plaintiff. There's been no counterclaim for fraud because we don't think that one can validly be pled, though they might try. And most importantly, what we said at the motion for continuance hearing, we said they have this witness, Mr. Hall. Mr. Hall is the one who verified their answer in saying that there was no consideration for this deal. Mr. Hall can provide an affidavit to attempt to defeat summary judgment, which is all they did here with the extra 3 months that they got. Kicking this can down the road does not.
So there was no written discovery and there was no oral discovery requested?
There was written discovery, Your Honor, but there wasn't oral discovery. There was a request for production of documents that was served and replied to in February, along with interrogatories. And both of those are attached to the defendant's response. But what we were told was that there would need to be depositions of each of the plaintiffs. So Mr. Lawson, Ms. Lynch, Mr. Torres. That never happened. We were told that there would need to be more done to investigate what happened with this deal so that Mr. Hall could file his affidavit. Well, what did we get? We got another affidavit from Mr. Hall that there doesn't appear to be any reason he couldn't have filed back in February. And the affidavit claims that within the first 6 months of them acquiring this business, the sales of the company fell off by 50%, which obviously is something they would have known in the first 6 months of having acquired the business. So what we have is we have a continued attempt, and I don't think it's counsel, I think it's the client, but we have a continued attempt to extend out this question of, is this note valid? Should this money be paid? And we think that issue should be resolved because under the case cited by both the parties, it's 4 simple facts, none of which are in dispute. And if they think they have an affirmative defense or a counterclaim, bring it. But otherwise, we're entitled to the summary judgment motion that we filed months ago.
Mr. Reed?
Yes, Your Honor. We did conduct written discovery and intended on doing oral discovery. Of course, the world changed in between when we had our continuance hearing and today. We did file a counterclaim for unjust enrichment. We are proceeding in this case, and these facts and their elements are in dispute, Your Honor, as shown by the summary judgment evidence. Counsel likes to argue that this note is a guarantee, but it's not. This is not a guarantee case. This is a promissory note that stands or fails on its own merit. And the simple fact is when asked what the consideration was for this note, that all they can point to is some benefit given to a third party, which is not consideration. And there's no case law cited for this court, nothing cited in their motion. And I couldn't find anything that a note that's given when there's the consideration of some undefined benefit to a third party within a sphere of companies is somehow consideration for a contract. And I can't find it. They haven't provided it. And that is simply an element to their claim is that they have a valid contract, which they can't show here as a matter of law, justifying summary judgment at this point.
Okay, well, I appreciate the argument. I'm going to take this under advisement. I'll try to get you a decision within the next 2 to 3 weeks. Go ahead. Have you guys both submitted orders for me?
You have, Your Honor. I will submit an order on that, the leave that you granted as well. I haven't submitted that yet.
And go ahead and submit one. Just, I'm not saying I'm denying it, but go ahead and submit one denying the summary judgment. And Mr. Ron, if you could submit one granting the summary judgment. All right. Anything else, guys?
No, Your Honor.
No, Your Honor.
Okay. I will get you a decision as soon as possible, and I appreciate the briefing. It was well done, and good luck and be safe out there. Okay.
Thank you, Your Honor.
Thank you.